Well, a big issue for landlords, particularly farm landlords, is the issue of liability for injuries that occur on the leased property. Livestock, machinery, and effects on the land itself can all spell potential trouble from a liability standpoint. But why is this a concern of the landlord? Well, joining us now with the answer for today's Rural Money segment is Professor of Ag Law and Taxation at the Washburn University School of Law, Roger McEowen. Roger, thanks for joining us once again. First of all, does liability follow legal ownership?
Well, that's a good question, Janet, and it's good to be with you. But no, it doesn't. It more often follows possession. So whoever is actually in possession of the property, most of the time the legal liability issues are going to attach to that person, not the actual owner, but the one that's in possession.
Do you have any examples that you might be able to share?
Sure, there are always lots of cases on this. A recent Indiana case points this out, and it's not necessarily a farm case, but it can arise in a farm context. But this is where the plaintiff in the case suffered a severe brain injury from a bicycle crash caused by dogs that the defendant's tenant owned that ran from the leased property onto a public highway where the plaintiff was bicycling. And the trial court granted judgment for the defendant, and that was affirmed on appeal because the defendant, the landlord, did not owe a duty, the court said, to the plaintiff. I think important in that case was the plaintiff didn't raise any type of nuisance claim at trial, which we can see that a lot come up in agriculture, and that can actually change the outcome where the landlord could be liable if the tenant is creating some type of nuisance that affects adjacent landowners.
And what is the reason for the rule of the landlord non-liability?
Well, it comes back to possession. That rule is that the tenant is the one that is there. They're in possession of the leasehold premises. They're the one that is present. They're the ones that can have the most to do about making the premises safe, and they have control over what occurs on that leased property.
And are there any exemptions?
There are a number of exemptions, but basically what it comes down to is if the landlord exercises control or charges admission to the premises or makes a promise to fix a defect on the premises and fails to do so or does so negligently, then the landlord can be liable. The big one in ag, however, is that if that tenant is creating a nuisance because of maybe their farming activities or spreading of manure that upsets the neighbors, and it can rise to the level of a legal nuisance, then the courts will say that the landlord is responsible along with the tenant for allowing the tenant to do that.
And what about, is a landlord also held responsible for injuries occurring on the leased premises caused by animals that belong to the tenant?
General rule would be no. That's going to be the tenant's responsibility. It would take a unique set of facts to make the landlord liable, but the tenant is responsible for their own animals.
All right. Well, Roger, thank you very much for your insight. Once again, we certainly appreciate it. Roger McEowen with the Washburn University School of Law joining us on the phone from Topeka, Kansas.